Okay, so you've tried settling your case. You've tried negotiating your case. You've gone to mediation in your case, and you still can't resolve it. He's unreasonable, he doesn't understand, you've got all kinds of conflicting, complicated evidence. What are you going to do? Well, you're probably heading to trial. Take a deep breath. Trial sucks, that's all I'm going to say. It's really hard on everybody. It's hard on you, it's hard on your family, it's hard on your children, it's hard on your ex. And if you're heading to trial, the chances of you and your ex being able to get along in the future are starting to diminish. Although some people are able to go to trial and put it behind them, and after a period of time passes, you know, time heals all wounds. But the truth of the matter is, if you're going to trial, you're probably in a situation where you're going to have to say some pretty nasty things about each other. Because you're trying to prove your case, he's trying to prove his case, and you're going to leave it up to a judge to make the decision about what's best for you and your family and your finances. Everything is typically on the table in a trial, although it's possible that you could settle finances and go to trial only on custody issues, or vice versa. You could settle your custody issues and go to trial only on financial issues. But typically, if people are in the position where they're heading for trial, pretty much everything's on the table. So how does this work? Well, first of all, most people heading to trial have a lawyer, but not always. And a lot of people go to trial on their own without a lawyer, and I've actually tried cases against people that are not represented by a lawyer, and they do pretty well. Judges are pretty understanding, and they're pretty sympathetic to the fact that someone is without a lawyer, but in most places they're going to hold that person to the same standards, to following the proper rules of evidence and following all the rules in your particular jurisdiction to prepare your case for trial. But anyway, at the end of the day, the most important thing as far as issue spotting, which is what we're trying to do here, is if you're heading to trial and you don't have a lawyer, you better familiarize yourself with all of the local deadlines and court rules where you are. If you have a lawyer, your lawyer should know those, and you're going to have to be prepared to meet with your lawyer a whole bunch of times to make sure that all of the information is provided in a timely fashion so that things can be prepared for trial. So first thing you need to understand about being in a trial and getting ready for trial is that there's a lot of rules, like we talked about, and there's also rules of evidence. And the rules of evidence are set up to make things efficient and to make sure that the information that gets in front of a judge is authentic and reliable. That's really kind of what it boils down to. So what judges do in divorce cases, and I guess there's a couple of states where they actually have juries for divorce cases, but I think they don't use them very much. Typically in a divorce, it's just you in front of a judge. But the judge is going to be looking at your evidence, which comes in different ways. One way that evidence comes in is testimony, which is when people testify under oath. And another way evidence comes in is called documentary, which means that there will be documents for a judge to review. But before you get to trial, most places you don't just show up to trial with a big bag of evidence and documents. Most places they kind of want you to be prepared before you get there, and it's completely different in different jurisdictions. But it's everything from telling you exactly what kind of binders that the judge wants, how they want the evidence organized, to showing up the day of trial with a binder full of evidence. Or not even in a binder, just a stack of documents that you're going to submit to the judge to review. At any rate, the point I'm trying to make is that you need to find out what the judge in your jurisdiction expects and make sure that you provide your evidence, and you work with your lawyer to provide the evidence the way that the judge wants it, that according to the rules in your particular jurisdiction. In most places, judges don't kind of arbitrarily just get to say how they want stuff. It's usually some sort of a rule in that particular area, in that county, or in that state. So the point I'm trying to make is that you're going to have a whole bunch of documents that you're going to want the judge to review, and it's going to be things like bank records and tax records and credit card receipts and maybe letters that have been written or emails or photographs. Those are all the documents that you want to admit into evidence, and then you're going to want testimony to be in front of the court. And testimony will be, when witnesses come in and testify. So what you're doing is you have to understand that that judge doesn't know you or your family or anything, so the only thing that judge is going to be able to rely on is the evidence that's admitted in court. And it's going to be your obligation, along with your lawyer, to provide all that evidence in a way that's required in your particular jurisdiction. So in preparing for trial, in most places you have to let the judge know who are going to be your witnesses. You have to sort of give them an idea of what documents you're going to be submitting into evidence. There's usually ways that those have to be numbered or labeled in some fashion so that when you get into trial, in a lot of jurisdictions, all that's done before trial, so when you get there, it's the best use of the judge's time. You don't want to be bumbling around looking to try to find, well, what was that credit card where I knew that he went to some hotel and didn't pay the bill, and I'm pretty sure, there was something in the bank records. So in other words, what I'm saying is that you want to be very well prepared with use Post-its or stickies or whatever you need to do, working with your lawyer to make sure that everything is pretty much at your fingertips, so that when you get in front of a judge, you are efficient and believable, and you kind of move your evidence right along. So some lawyers actually hire trial consultants to sit down with their client before they go in front of a judge to help you to figure out how to answer the questions in a way that makes you look good. So that's a possibility. Your lawyer is going to probably want to meet with you a lot and go over your testimony and kind of outline how it's going to go, because what you don't want to do really is you don't want to be heading for a trial and your trial's tomorrow and you haven't talked to your lawyer and you haven't thought through how you're going to present the evidence to the judge. Because like I said, all the judge knows is what you tell the judge and what the judge sees in documents and what other witnesses tell them. So you want to make sure that you understand what's going to be presented to the judge, how it's going to be presented, and then you want to have some input into, how does that look, and is that exactly right, and is that the way I want it to kind of come out? And that kind of takes us back to your vision, like how do you want to be in this situation? Do you want to look like the angry, spurned wife, or do you want to look like, put together and, smart and articulate and, somebody the judge is actually going to like and want to find things in your favor because of how you present yourself? So you want to talk to your lawyer, or if you don't have a lawyer, you want to think about how you're going to dress for court. I always tell my clients to dress like you're going to a job interview. I had a client, and we just went to trial a few weeks ago, and this is a woman who's got kind of platinum bleached hair. Every time I've ever seen her, she's in an AC/DC type t-shirt. She always has studded jeans. She has cute little stiletto heels. She's kind of a tough looking gal. She's got several kids and she's a real good mom, but she doesn't look like June Cleaver, let's just say. And we walk into court the first day and her husband just looks at her and he had this most weird look on his face, like, what? She's there in a little lavender sweater set. She got a little pink bow in her hair and she looked like, she just walked in out of the PTA. So I'm not saying you should try to be phony, but at the same time, you don't want to come in and look harsh, or you want to make a really good presentation to the judge. As far as your demeanor in court, most judges, want people to be, it's kind of obvious, you want to be very respectful. You don't want to argue with the judge. Here's what you don't want to do. If your ex is up there testifying or one of his witnesses, you don't want to be sitting over here going, you don't want to be throwing your pen down, you don't want to be rolling your eyes, you don't want to be snickering. Judges notice that, and I've had judges on a number of occasions actually tell people to knock it off. Or you don't want your friends in the, they usually have those pews kind of in the back there, you don't want them giggling or pointing, or everybody needs to be pretty cool and be respectful of the process. Another thing I want to be really careful to think about is that when the judge is not on the bench, well, just because the judge isn't in the courtroom doesn't mean that their staff's not listening to you. So if you're talking to your lawyer and saying something bad about your ex, or I had a trial I had just finished, I don't know, maybe 6 months ago or so. My client was kind of a hothead and he started kind of yelling at people when the judge wasn't in there, and the judge came out on the bench and she looked at my guy and said, "Don't think I don't know how you're talking to people out here, because my bailiff's sitting right here and he heard you." So from the minute you walk in the courthouse, basically, you're sort of on, I don't want to say display, but you're on stage. And so when you're sitting out in the hall, sometimes in some courthouses, the judges actually have to walk down the hall to get into their courtroom, and you don't want to be out there snickering or, acting unprofessionally in any way. You want to be serious and smile at the judge and say hello. But all of this stuff, it sounds kind of staged, but it's super important because judges they don't know you. And they're only going to get a snippet of you and your life. And you just have to do one thing to make a bad impression on a judge, and it clouds the whole case. You could have the best evidence in the world. You could have binders and sticky notes and all this evidence of, how bad your ex is and all these things he's done. But if you've been somehow unprofessional or disrespectful to the judge, they just kind of might not like you. And a lot of what judges have to decide, they have to weigh the evidence, but they also have sort of a gut reaction to people. So here's the warning. from the minute you walk in the courtroom or courthouse, imagine that the judge sees you and knows what you're doing, because you don't know who in that courthouse that you're in the elevator with when you're talking to your lawyer saying what a jerk your ex is. That could be the judge's clerk or something and you didn't realize that. So be very cognizant of that and be really careful when you're in the courthouse to always look professional and to be, serious and respectful.